Good morning. Happy Sunday. We did the debate last night. By we, I mean me and guys, I guess, from a different Discord server who came in to be disruptive. And it was about as much fun as you would expect a debate to be with people who don't know what they're talking about and aren't taking it seriously. I don't particularly see the law as a good topic for debate. I think the law is a much better topic for research, providing your sources so that each side can review the sources so that you can see the basis of any claims that are being made. Debate, I think, works better with things like philosophy, religion, politics, things like that. Things where things that are more based in opinion than they are based in stare decisis or the actual text of a statute. That being said, the reason why I did it, again, is because I have been accused of not making myself available to debate these topics. Now, while I did not have a verbal debate with Teresa over the last roughly week, I have been discussing in my Discord section with her, maybe not the last week, maybe the last 2 or 3 days. I have been discussing in my Discord section with her the various aspects of her claims and why I disagree with her interpretation. Before I get off this particular page, though, I do want to point out that this claim right here, and I want to point out this claim right here because I did this video on the 20th. And she actually posted this the same day, I believe. I know it says 3 days ago, but I don't control YouTube. She said, "I never mentioned HIV, you did." Now, one thing that I believe you need to have in order to actually have a meaningful discussion with someone is you have to have the ability to say, "I was wrong." You have to, in law, whenever someone says, a reasonable person, what the law intends is a reasonable person who has the ability to change their mind if the facts and the law suggest a different result. It's kind of implied in a reasonable person. There's not much use in debating an unreasonable person. And for example, I did this just to show. She said here that she never mentioned HIV. I did. Well, as luck would have it, Discord puts date stamps on things. This is a citation to the American Journal of Public Health. This link right here. That is this article. This article that mentions AIDS. Now, AIDS and HIV are part and parcel. They're different aspects. One is a symptom of the other, I guess. Maybe I'm not a medical expert. I might be saying that wrong, but one leads to the other. One is the full-blown expression of the other. I think AIDS is symptomatic and HIV is non-symptomatic, but maybe I'm wrong. I'm probably wrong. But so she mentioned it. She mentioned HIV, which, there you go. And 7 days ago, 8 days ago, 9 days ago now. But at least 5 days before I made the article, or before I made my video. She mentioned again on the 15th. She showed this link. This is to Arlene. This is the School Board of Nassau County v. Arlene, where her search term included HIV. Imagine my shock thinking that she was talking about HIV. Oop, there we go. Here again on the 15th. That is why they cannot keep HIV positive children out of school. Again, she brought up HIV. I don't know why I have that in there. Anyway, yeah, so we're back to this. So she mentioned HIV at least 3 times. At least 3 times. So I brought it up. I said, hey, just admit you're wrong. and she wouldn't do it. She wouldn't do it blatantly. She would not state it explicitly that she was wrong. That's not, to me, that's not someone who's being genuine. But I am still here to answer the question because I enjoy these kinds of things. So we've gone full circle. This is the same article. This was just published yesterday, the 23rd. She cites it again. So this is her deal. And she says, here are some lawyers that don't agree with you, Merb. And then she quotes, in our view, any discrimination against persons with an infectious condition, which has no reasonable scientific public health justification, should come within the remit of Section 504. Should. In our view, it should. In our view, it should. In their opinion, their aspirational hope is that it does. But it's not quarantine. They're talking about any discrimination. So discrimination generally. So there's three things about that particular sentence that make me believe that they are not strictly addressing quarantine, that they don't have anything other than their hopes, their aspirations that it will, and it is their opinion that it should. And then this is a longer citation from the same article. You see, in our view, any discrimination, blah, 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 Section 504. This was written before the R-Line case was heard, decided by SCOTUS. And then she has a screenshot of from the R-Line case down there. So she's really basing her entire argument on this one document. So in order to address it, I have to actually look at the document that she's provided. Because who knows, it may actually completely rebut everything I've said, that Section 504 doesn't apply. Section 504 applies to employment, programs, services, and benefits. So in order for this document to prove me wrong, it's going to have to show that 504 applies to quarantines. Now, the title of the document is Legal Control Measures for AIDS, Reporting Requirements, Surveillance, Quarantine, and Regulation of Public Meeting Places. So you have reporting requirements, which matches up with the title, reporting requirements. Next will be surveillance. There's where it discusses surveillance and contact tracing. And then you'll have quarantine, personal control measures. That's how they title quarantine. It's this entire section is quarantine. And then regulation of public meeting places. Regulation of public meeting places. So there are those four sections. Now the quote that she took is from right here. This is the quote she took. This is the section for personal control measures, quarantine, and this is the quote she took. Quarantine, the quote she took. Now, in the introduction, it does talk about quarantine. It talks about quarantine right up here. And let's see what they have to say about it. Let's see where they show that it's unconstitutional or that Section 504 applies to it. The courts have upheld a wide range of public health powers, such as immunization. Look, there's that 7 there. That means there's a footnote. They're citing to something. They're going to cite all the way through, down through 15, right? So we're going to look down through 15. So from 7, this is a Supreme Court case. This appears to be a state court case, state, SC is South Carolina, so state. So through 15 is all state court cases. So immunization, surveillance, and reporting. I think this immunization one, this is Jacobson versus Massachusetts. So I think upon hearing that, Blue Bacon just got a hard on. Surveillance and reporting, compulsory examination and treatment, period, with 9 and 10. Okay? Now this is a new sentence. Quarantine amounts to compulsory deprivation of liberty and should attract the strictest judicial scrutiny. Notice it says should, and notice there's no citation. Those tell you that this is an opinion. The authors have inserted an opinion for their aspirational hope into a bunch of actual discernible facts. Because this piece right here is intended to persuade people. That's what this is. They're not telling you what the law is. They're telling you what, in their opinion, the law should be. Nevertheless, courts have repeatedly upheld quarantine during periods of epidemics. So notice that they say quarantine should attract the strictest judicial scrutiny. Nevertheless, despite their aspirational hopes, reality is courts have repeatedly upheld quarantine during periods of epidemics. Venereal disease, citation. Tuberculosis, citation. Smallpox, citation. Scarlet fever, citation. Leprosy, citation. And cholera, citation. Judicial subservience to compulsory health powers has occurred even where it was difficult to observe a reasonable relationship between the measure adopted and a preventable harm. For example, a quarantine of an elderly woman with aesthetic leprosy with hardly any danger of contagion. Citation. So from this, we can determine that the courts have upheld a wide range of quarantine restrictions. So then this paragraph. Let's just deal with this paragraph really quick. The Arline case, which is the School Board of Nassau County versus Arline, which involves the dismissal of a school teacher with tuberculosis. She was terminated from her employment, is currently before the U.S. Supreme Court. The United States Justice Department has argued that the Supreme Court should construe Section 504 narrowly. In a memorandum to the U.S. Department of Health and Human Services, it concluded that an individual's, real or perceived, ability to transmit the disease to others is not a handicap, and therefore discrimination on this basis does not fall within Section 504. They go on, this opinion is not supportable by legal analysis or scientific fact. That's, again, no citation, but it is, before Arline was decided, it was. You could make a good argument for it. That's why the United States Justice Department, which is full of attorneys, some very good attorneys, some excellent attorneys, with all the money of the United States behind them to spend however much time they need researching, came up with this interpretation. Ultimately, it wasn't right because the Supreme Court said otherwise. But it was a reasonable interpretation. Clearly, anytime somebody uses clearly, they're trying to psychologically manipulate you into thinking that what follows has already been proven. It's a propaganda tool, and lawyers use it all the time. My boss uses it incessantly. Clearly, people with AIDS or AIDS-related complex have a disability limiting their major life functions. I believe so. Under the analysis of the Section 504 definition for disability, I believe that is a correct statement. And those with HIV infection may be perceived by others as having a handicap. That is also, I think, a correct statement. If you have HIV, you may be perceived by others as having a handicap. I think because HIV is the asymptomatic version or stage of the illness, then it probably isn't a handicap in and of itself, but it may be perceived as having a handicap or being a handicap. This brings HIV disease well within the definition of handicap in the Act. I believe that is correct. The Justice Department memorandum takes the position that discrimination because of the fear of transmission is not based on a handicap, but upon a health risk to others. That is the position that they took. Yet the scientific community, they have tacitly given up the legal argument, and now they're saying science says this. So we're no longer making a legal argument. Now we're looking at science. The scientific community has empirically demonstrated the absence of any material risk of transmission of HIV from casual association. Okay. And then they go on with, in our view, and again, this is aspirational and it's opinion. In their opinion, This is the way the law should be. They're saying it in context of the R-line case, so I believe that it is limited to employment, is what they're arguing. Employment and other aspects of Section 504. Well, I don't know if you really want me to read the entire personal control measures section. There's not a whole lot of actual discussion of laws. They discuss states that have actually made a statutory basis for the detention of recalcitrant AIDS patients. So that's one state that's done it. That's not discussing the Constitution or Section 504. Another state has changed it so that have upped the due process requirements to raise the burden of proof to clearly necessary. I can't highlight it because it's already highlighted, but see this. No, not clear. I'm sorry, clear and convincing. Where's clear and convincing? A clear and convincing standard of proof right down here. So one state has required clear and convincing standards of proof for quarantine. But that's what a state has done. That doesn't mean anything. Different states can do different things. Each state has its own legislative body. Each state has its own state court system to interpret those statutes. So each state is going to come up with a different framework. That's why we are the United States of America. Each state has the power to control how it does its own quarantines. The one case they do cite in here, and it's for whenever a state interferes with personal liberty, it must first explore less restrictive alternatives to achieve the public health objective. And it cites to Shapiro. Public health objective cites to Shapiro. Shapiro, unfortunately, does not deal with public health. Shapiro versus the Commissioner of Welfare in Connecticut deals with states not allowing people who have recently moved in to the state to take part in state benefits, AFDC benefits. They were denied AFDC benefits, and this one was denied aid to the permanently and totally disabled. And denial in each case was on the ground the applicant had not resided in the District of Columbia for 1 year, immediately preceding the filing of her application. So the issue in this case is getting benefits. Programs, services, benefits. Programs, services, and benefits. And in this case, it was denied based on the right to travel, which is a constitutional concern. You have a right to travel, and by that right to travel, states can't treat you differently based on your state of residence or how long you've lived there or anything like that. Constitutional right to travel from one state to the other occupies a position fundamental to the concept of our federal union. It is a right that has been firmly established and repeatedly recognized. So in this case, since there is a constitutional concern, it requires strict scrutiny. The state has to have a compelling, somewhere in here I'll say it, probably a compelling reason to make the distinction. And it has to be the least restrictive. It has to be the least restrictive method of doing so. I don't know where it says it in here. I can't read and talk at the same time, so you'll just have to believe me. The link will be in the description if you want to read it. So it doesn't deal with quarantine, and they state it very broadly. Where am I? They state it very broadly in here. I think they overstate what it is. And if you notice, if you go down to 41, they don't actually give you a page cite. They just say generally see Shapiro v. Thompson. And that's not like, for example, on 18, this is the citation right here. That's what you would look up to find the case, but they're referencing specifically pages 650 and 651. So they're actually giving you a very narrow cite down here. Allied Stores of Ohio Incorporated v. Bowers. This is the citation, and then what they're referring to is on page 527. They made a very generalized statement for Shapiro, and because they made it very generalized, they can't really cite a page to it, and I believe they've oversighted it. But you could read it and you could determine it for yourself. But nowhere in here, nowhere in this entire section, does it mention Section 504. Nowhere does it mention Section 504. And I will leave a link to this in the description as well, so you can read it. And you can see that there is no mention of Section 504 in the entire quarantine portion, personal control measures. I have highlighted in this entire document where they have mentioned quarantine, except for the title. That's the only other place they've mentioned quarantine. They mentioned quarantine in this portion right here, and then they mentioned quarantine in this section right here, where it's highlighted. I think quarantine. I believe there's 8 total mentions of the word quarantine, and except for the title, they are only in the highlighted sections. So the question is, does Arlene and Section 504, this is Section 504, by the way, so right down here where this is Public Law 93-112, Title 5, Section 504, this public law was codified in the 29 U.S.C. 794. This is Section 504, and this is the language they're discussing. Now, some things I want to point out. This is in labor. This is in vocational rehabilitation and other rehabilitation services, rights and advocacy. So this is really focused on labor and vocational rehabilitation and other rehabilitation services, but it is broader than just that. This is 45 CFR 84.3. These are regulations promulgated by the Department of Health and Human Services. And this is based on the Act. This is the Rehabilitation Act of 1973. 504 means Section 504 of the Act. And what they have done is they have basically broadened or refined. There's more text to it, so you can get a better idea of how they are interpreting that particular statute and how they are enforcing that particular statute. So this is the definition of qualified handicapped person. This is the otherwise qualified individual. With respect to employment, well, we would deal with Arlene here, a handicapped person who, with reasonable accommodation, can perform the essential functions of the job in question. That is a qualified handicapped person for employment. Well, then there's public preschool, elementary, secondary, and adult education services. Well, in this document, just so we're all on the same page, at the very beginning, before they start talking about Arline, they talk about 2 cases. They talk about New York State Association for Retarded Children v. Carey, which concerned hepatitis B, and they talked about District 27 Community School Board versus the Board of Education of the City of New York, where the New York upheld a citywide, or where New York struck down a citywide policy of excluding kids. So they upheld a citywide policy of not excluding kids with AIDS from school. So you might notice that those 2 cases both deal with school. This is the first one, the Association of Developmentally Disabled Children versus Carey. It was a much more honest and open time back in the 80s or late 70s. And then you have this one, the School Board versus Board of Education. Supreme Court doesn't mean it's actually the Supreme Court. The Supreme Court in New York is the trial court, and then it goes from the trial court, you would appeal to the appellate division, and then you'd appeal from there to the Court of Appeals, which is Supreme Court's highest court, or which is New York's highest court. It is the fundamental equivalent of the Supreme Court in every other state. So this is a trial court, not really meaningful. The issues, though, with these 2, this one with the developmentally disabled children, they had hepatitis B, or they had the serum, hepatitis B serum, which means they may or may not actually show symptoms of hepatitis B. but the court said that you can't treat them differently without going into a more particularized sort of analysis. You have to use the same sort of analysis that was in Arline. I have it in here somewhere. Here we go. So the particularized kind of language that you had to use was the wait, why are we in footnotes? Somewhere in here. Why can't I find this? There we go. So they agree that it should include findings of fact based on reasonable medical judgments given the state of medical knowledge about the nature of risk, the duration of the risk, and the severity of the risk, and the possibilities that disease will be transmitted. And then the next step is to see whether or not the employer could reasonably accommodate the employee, or in this case, the next step for the kids with hepatitis would be to see whether or not the school could reasonably accommodate those children under the established standards for that inquiry. So that was this one. This is a federal Court of Appeals case. And then the same sort of analysis was for the kids with AIDS or HIV. I don't know if they had AIDS or HIV. Doesn't really matter. Anyway, so Section 504 does deal with allowing kids with handicaps access to public preschool, elementary, secondary, or adult education services. So those cases, you can see why those cases would use Section 504. It also deals with post-secondary and vocational education services. So like college and one of those technical institutes or career colleges or whatever they call them, where you learn a trade or a skill. It would apply to those as well. And then finally, the only other place it applies is with respect to other services, a handicapped person who meets the essential eligibility requirements for the receipt of such services. Well, the problem is that a quarantine is not a service. So it just doesn't apply. It's 504 deals with programs, services, and benefits. It doesn't deal with quarantines. And I get what Teresa's trying to do, what she wants to do. She wants to say that this somehow applies to quarantines, and it just doesn't. That's why it's not in the quarantine section. If they thought it actually directly applied to quarantines, they would put it in the quarantine section. They would make an argument that it should apply to quarantines or something like that. Now, I'm not saying that in the future, the Supreme Court might look at a right to travel case based on quarantine or a Americans with Disability Act based on quarantine. That might happen. It could happen, and I could be wrong. But there's nothing in this particular paper that would suggest that I'm wrong, except in their opinion, their aspirational hope that it should be that my analysis is wrong. But unfortunately, they can't cite anything to support that. So what Teresa should derive from this case is public policy. Because if you go down to their section on personal control measures, i.e. quarantine, they talk a lot about public policy. I wonder if I could search this document. Can I search it? There are numerous public policy reasons against a general isolation. More limited isolation suffers from many of the same public policy objections. Even if the courts were to uphold limited isolation, there are distinct public policy reasons that make them weak candidates. Public policymakers can be virtually assured of judicial and political support for compulsory public health measures to control the spread of AIDS, which are carefully based upon the current state of scientific understanding. This is an accurate statement. I have no problem with this statement. Just because a state has the power to make a quarantine against persons with HIV or AIDS doesn't necessarily mean the public is going to support it. In fact, when you look in here, even in 1987, it was isolation of HIV carriers is claimed to be favored by 42% of the public. In case you're bad at math, that is a minority opinion. Most people do not support quarantining persons with HIV or AIDS. I've never made an argument that persons with HIV or AIDS should be quarantined. But my personal opinion on whether or not persons with HIV or AIDS should or should not be quarantined does not affect the state of the Constitution as it is currently understood by the Supreme Court and lower courts, nor does it change the interpretation of Section 504 as it is currently understood by the Supreme Court and lower courts. And so I have to sit here and say that the states have the power to quarantine people at least as low as a reasonable cause that a person is infected and infectious. Just because they have the power to do it doesn't mean that they are going to do it. For example, in California, there are actually statutes in place for the control of tuberculosis, specifically authorizing courts to get involved to commit people with tuberculosis who are not able to comply with basically a self-quarantine and a self-medication treatment program regime. And the reason why they defer initially to trying to get people to comply with it is probably because it's less costly. The public won't be as upset by it. People tend not to like other people being forced into confinement. Like one of my biggest fears in life is someday being committed into an insane asylum. It is to me ridiculously easy to get someone committed to an insane asylum, at least for a short period, 72-hour duration initial observation. But all it takes is a couple people to say this guy is suicidal and crazy, and you get in front of a court. If you convince the court, boom, off to the asylum, and then at that point, people with psychologists will get to interview you and observe you and see, and hopefully they'll come to the right decisions. But that's a huge concern. Like I've had nightmares about that because it is just so ridiculously easy to do. But that doesn't change whether or not, my personal fears about it don't change whether or not it can be done, because it can be done and it is done. People get committed all the time. And it's an unfortunate fact of life that's the way it happens. But anyway, I hope that makes sense. I hope you see where I took the teeth out of her argument that this particular paper somehow undermined my assertion that at a minimum, well, I don't even know if it's at a minimum. I don't know what the minimum is, but I do know that at least in California, with the minimum of due process, i.e. a reasonable cause that someone is infected and infectious, they can and have been quarantined. So anyway, thanks for watching. Have a great day and good luck on your panel tonight, Teresa. I hope you find a worthy debating partner.